Guys, today's course is called Rule 43, Holding Patterns Explained. Let's get into it. What we're going to look at today is an overview on Rule 43. Please do not consider today's webinar to be absolutely exhaustive. Rule 43s are absolutely monstrous applications. They are incredibly complex. They need a high level of sophistication and real drafting savvy to be successful. They are not simple applications, which is unfortunately due to their evolution over the years. They were obviously intended by the rules board to be expeditious and quick and simple. They are unfortunately not. So first off, we're going to be looking at the purpose and the scope of Rule 43. Thereafter, we're going to be taking a quick look at the process. Then we're going to look at some key principles regarding Rule 43, and then a little bit of notable case law will also be raised during today's presentation. So folks, right from the get-go, I want to delve into the question and really go back to basics and try to postulate, what is Rule 43? Is there a way to sum up the real crux and nucleus of Rule 43 in a single sentence? I have tried my best to contain a definition in one sentence. Even looking at it now, I know that it is open to some criticism. One can simply not cover all of the angles in a simple one sentence description, but I think for our present purposes this is a good starting point. Now, before I get the question at a later stage, Rule 43 is obviously the High Court rule for interim issues in matrimonial matters. Rule 58 is the real equivalent in the Magistrates Court. Today I'm going to be talking simply about Rule 43. In a big sense, the principles of Rule 43 can be transposed as is to Rule 58. Obviously, just being in the Magistrates Court, there are one or two things that are a little bit different, but for the most part, the same principles apply. So without further ado, what is Rule 43? And this is the definition that I've tried to postulate in one sentence. Rule 43 is an expeditious and robust High Court application which is designed to, by means of interim court order, give rise to a tenable and fair temporary status quo in respect of maintenance, legal costs, and care and contact of minor children, pending finalization of the litigation in divorce matters. I'm going to go on one slide where I've highlighted some of the core concepts which I want to talk around in terms of Rule 43. Rule 43 is designed to be expeditious and robust. Expeditious simply in terms of they are meant to be dealt with quickly. They are not intended to bloat. They are not intended to be a huge protracted affair. The parties file statements, sworn statements under oath, much in the form of a plea. This in and of itself has become a problem, as I'm sure the attorneys amongst us will tell you. This has come to the point where to really take the court into one's confidence, one has to walk a tightrope between conciseness, accuracy, and really acting with the uberime fides that is required, the utmost echelons of good faith, as some of you might know were referred to in the Dupree matter, where the judge made some serious statements about applicants not making full and honest disclosures to the court. Rule 43 matters are dealt with in a robust fashion. They really do require the judges hearing them to make very decisive orders to set in place this status quo in an interim fashion. I haven't highlighted High Court, Rule 43, obviously High Court, Rule 58, Magistrates Court. It is an application proceeding. It's not on notice of motion. It's got its own Rule 43 notice, but in most cases, they are heard much in the style of an application proceedings. What is the end result of a Rule 43? Unless it gets dismissed, you get an interim court order. It has all the full force of a court order, but it is interim in nature. The minute the divorce is granted, it falls away completely and is replaced by whatever the trial court decides in terms of the final outcome of the divorce proceedings. It is meant to give rise to a tenable and fair temporary status quo. The Rule 43 court is not going to reinvent the wheel. The Rule 43 court is not going to make serious findings in terms of, for example, a termination of guardianship in respect of children. In fact, the rule doesn't even mention the term guardianship. The Rule 43 court, in the truest sense of the word, is designed to put parties in a holding pattern where they can get to court properly and without one party having an unfair advantage over the other. Rule 43s deal with maintenance, contributions to legal costs, and care and contact in respect of minor children. And as I mentioned previously, they operate pending finalization of the litigation in divorce matters. This obviously gives rise to some implications, which we will deal with a little bit later in terms of the nature and the scope of Rule 43 applications. But in a nutshell, this is the beast that we are dealing with. Right, so what does Rule 43 provide? The rule itself has the heading in the Uniform Rules of Court, Interim Relief in Matrimonial Matters. So the Rules Board was quite clear when they promulgated the rule that it is interim in nature. And the rule reads as follows, not the entire rule, I'm just quoting subsection 1, which really gives us the scope and ambit of the rule. This rule shall apply whenever a spouse seeks relief from the court in respect of one or more of the following matters. And then it lists 4 aspects. 1, maintenance pendente lite. 2, a contribution towards the costs of a matrimonial action pending or about to be instituted, interim care of any child, and interim contact with any child. Those really are the 4 pillars on which Rule 43 applications are adjudicated. Ladies and gentlemen, a very, very notable absence, if we look at the wording of Rule 43 sub 1, is guardianship. The rule specifically applies to A, maintenance, which for some reason they've separated between maintenance and care and contact, and they've put contribution there in the middle, but be that as it may, c'est la vie. As I mentioned, the 4 walls of Rule 43 are maintenance, contribution towards the costs of a matrimonial action pending or about to be instituted, interim care of any child, and interim contact with any child. Now, very interestingly, guardianship is specifically not listed here. The court, I would go so far as to say, will be very loath indeed to deal with any issues of guardianship under a Rule 43 application. And I think it is with reason that the Rules Board did not include guardianship together with the other 3 pillars of parental responsibilities and rights, being care, contact, and maintenance. So let's go through the pure basics of Rule 43. What are we dealing with in a Rule 43 application? First off, we start with maintenance pendente lite. Pendente lite, ladies and gentlemen, simply means pending the litigation. So this is a maintenance order that will be in place until such a time as the litigation is finalized. Maintenance can be divided up into 3 categories. First off, we deal with maintenance for minor children. Thereafter, maintenance for major dependent children, and then finally our very favorite spousal maintenance. Right, let's go through them. Section 18.2 of the Children's Act, and let's start off with minor children's maintenance. Section 18.2 of the Children's Act provides that the parental responsibilities and rights that a person may have in respect of a child include the responsibility and the right, and under subsection D, to contribute to the maintenance of the child. Very interestingly, folks, in terms of the Children's Act, we have a very, very good definition under the definitions for care. We have a very good definition for contact, and not in the definitions, but under section 18.3, we have a very good definition of guardianship. However, we have absolutely no definition in the Children's Act or in the Maintenance Act, for that matter, of maintenance. I don't know whether the legislature deemed it to be so obvious that no definition was required. However, I am going to borrow from one of my other slides, being in terms of the concept of care. If I can just find my slide that deals with care in respect of a minor child. That is under the Children's Act definition. You will see that under the definition of care, there is specific provisions with regards to looking after the financial needs of the minor child, and we'll go through that fully a little bit later. So if you ever do need a definition for maintenance, please go and look under care. But where does the responsibility of parents to financially maintain the child, if it is a minor child, arise from? It is a statutory responsibility in terms of section 18.2 of the Children's Act. So folks, when dealing with Rule 43, and you have co-holders of parental responsibilities and rights, understand that minor children's maintenance can be considered a given. It is, as we say, res ipsa loquitur. The child is the child of these two parents. They have full parental responsibilities and rights, and they must, without any further argument, according to their available means and the needs of the child, maintain the child. Now we sit with an interesting situation, folks, when the child reaches 18 years of age. They are, for all intents and purposes, majors. However, we know that turning 18 is not a panacea, and it is not a miraculous event where all of a sudden the child is 18 and now they look after themselves. 90% of the time children turn 18 when they are in matric. At that stage, it speaks for itself that that child is not yet going to be self-supporting or self-sustaining. And in that regard, fortunately, the common law has come to our aid, and specifically in the form of various very interesting cases which have made their way through our court system in the recent past. In fact, the most recent of which is a judgment from the Supreme Court of Appeal, which has not yet even made its way to the law reports, which I have no doubt will make its way to the law reports, and that's Z versus Z, case number 556 of 2021, and its neutral citation is ZASCA 113, and that's 21 July 2022. Now, the background, folks, of Z versus Z was the following. We have for some time in South Africa been in a very funny position in terms of maintenance for major dependent children, where some people would say, the child must claim it themselves, or others would say that the parent can claim it on behalf of the child. It has been well established, incidentally, that for some time in South Africa, the responsibility of parents to maintain their children post gaining the age of majority or attaining the age of majority. That has been a given for some time. What has, however, been a big question has been, can the parent claim maintenance on behalf of the child if the child is over 18? And this is where Z versus Z has come to our aid. And specifically at paragraph 22 of the judgment, ladies and gentlemen, the court says, an interpretive analysis therefore leads to the inevitable conclusion that sections 6.1c and 6.3 of the Divorce Act vest parents with the requisite legal standing to claim maintenance for and on behalf of their dependent adult children upon their divorce. In other words, folks, if you are getting divorced and you have major children, you can claim maintenance on behalf of your major dependent child. It's a very interesting judgment in terms of seeing the rationale that the SCA took. And one of the things that they did highlight, albeit obiter, was the imperative that they don't want the poor child to have to enter into the fray and take their father or their mother to maintenance court. One can imagine the embarrassment and discomfort that that would really lead to in terms of a child. Now, Z versus Z is very, very interesting in that it really solidifies and crystallizes something which a lot of us have been applying for some time. It's that upon divorce, one can claim maintenance for a major dependent child. By proxy, one would then be able to, in Rule 43, set the holding pattern. It is tried case law that you can't seek anything in Rule 43 which you can't get in divorce. So the corollary of that is if you can seek it on divorce, you can seek it in Rule 43. If we go back to the wording of Rule 43, it's very interesting to note. It simply says maintenance pendente lite. It does not specify whether it's spousal maintenance. It doesn't specify whether it's maintenance for minor children. It doesn't specify whether it's maintenance for major dependent children. Maintenance, full stop. So I would posit that it is worded very, very broadly in terms of any person to which one may have a duty of maintenance support can receive assistance under the sub-rule. Then finally, folks, let's go on to the issue of spousal maintenance and where it derives its claim from. Now, we know that in terms of South African common law, if we can take a step back, that parties have a reciprocal duty of support to one another during the course of a marriage. A good example of that reciprocal duty of support is my poor dutiful wife going to buy petrol for my generator so that I don't make my name Popo in this webinar due to Eskom's lack of cooperation. My wife is probably not going to take me to small claims court to claim the $200 that she spent on petrol for the generator. That all forms part of the reciprocal duty of support between spouses. However, when a marriage comes to an end by virtue of decree of divorce, that reciprocal duty of support comes to an end and you can no longer rely on it. When you are divorced, you are divorced. And you are no longer husband and wife, and you cannot claim the reciprocal duty of support between spouses. The legislature, all the way back in 1979, foresaw this in our Divorce Act, and Section 7.2 of the Divorce Act came into being. And what Section 7.2 really is a laundry list of factors which the court must consider when making an order for spousal maintenance at divorce. Mediators, please make a very, very big note of Section 7.2 when mediating a dispute regarding spousal maintenance. Have a look at these factors. Attorneys make a big note of this. A lot of attorneys make this mistake in Rule 43. They do not plead the jurisdictional factors in terms of section 7.2. You get a sharp attorney and a sharp counsel on the other side. They are going to take a point. And for heaven's sake, do not claim spousal maintenance in Rule 43 if you don't claim it in your particulars of claim or in your counterclaim. You will have a point taken against you. The section reads as follows. In the absence of an order made in terms of subsection 1 with regard to the payment of maintenance by one party to the other, the court may, having regard to the existing or prospective means of each of the parties, their respective earning capacities, financial needs and obligations, the age of each of the parties, the duration of the marriage, the standard of living of the parties prior to the divorce, their conduct insofar as it may be relevant to the breakdown of the marriage, an order in terms of subsection 3, and any other factor which in the opinion of the court should be taken into account, make an order which the court finds just in respect to the payment of maintenance by one party to the other for any period until the death or remarriage of the party in whose favour the order is given, whichever event may first occur. I nearly passed out reading that. That is a big mouthful, ladies and gentlemen. Let's simplify it. Let's go to the next slide. Here is section 7.2, the exact same section. All I've done is I've put every factor into a bulleted point. And use this as a crib sheet. You are absolutely welcome to. It is going to make your life a lot easier. The court may, having regard to 1, the existing or prospective means of each of the parties, 2, their respective earning capacities, 3, their financial needs and obligations, 4, the age of each of the parties, 5, the duration of the marriage, 6, the standard of living of the parties prior to the divorce, 7, their conduct insofar as it may be relevant to the breakdown of the marriage, 8, an order in terms of subsection 3. Those of you who attended our KRG webinar will remember subsection 7 subsection 3, which is a transfer of assets during the which can be granted upon divorce. And then finally, any other factor which in the opinion of the court should be taken into account. It may make an order which the court finds just. That is the test for the court. What order will be just? And to determine what would be just, the court looks at the laundry list which I have recited for you. And the court may then make an order in respect of maintenance by one party to the other for any period until the death or remarriage of the party in whose favor the order is given. Now, that is the section 7.2 jurisdictional factors. Now, understand, folks, that I said earlier, maintenance between spouses is part of the reciprocal duty of support between spouses. However, there is case law to suggest that you cannot claim anything more in Rule 43 than you could claim at divorce. So make sure that when you formulate a Rule 43 claim, that you set out your section 7.2 factors, even if you do so briefly in the body of your affidavit. What form can a maintenance claim under Rule 43 take? Number 1 is periodic payments of money to the applicant. Number 2 is periodic payments of money to service providers, i.e. school fees. Number 3, assets can be made available for use by the applicant. And that is Van der Spy versus Van der Spy, 1981. It is a reported judgment that you can refer back to. Those really are the 3 types or the 3 subspecies of maintenance that one finds under a Rule 43 claim. Very interestingly, Erasmus, in their commentary on the High Court Uniform Rules, suggest that under the sub-rule, lump sum payments are not permitted in terms of maintenance. They can be permitted in terms of a contribution to costs, which we're going to look at next. Then let's look at the second thing that one can deal with in Rule 43, and this is a contribution towards the costs of a matrimonial action pending or about to be instituted. And some of the most bitterly fought Rule 43s that I've seen have been fought over this contribution to costs. And one can understand why. In an acrimonious divorce, the last thing that a spouse wants to do is to pay for the lawyers of their spouse to make their life difficult. So these are generally quite hotly contested claims. There are specific ways to ameliorate the risk of a contribution to costs for one's client. However, I'm not going to go into that within this webinar. I'm going to just speak in very brief in terms of what the overriding principles are that we are experiencing or that are being applied at present in terms of contributions to costs. The key principles in contributions to costs, I think, are fourfold. Number one, to get a contribution to costs, the applicant must show a prima facie case if they are the plaintiff, or they must show that they have a sound defense if they are the defendant. They don't have to prove that defense, they must just show prima facie. In other words, they must show enough facts which, if proven, would give them a valid case and or a defense. Then, incredibly important, folks, when you prepare your bill of costs for a contribution, or when you attack a bill of costs against a contribution, this has recently, I'll share anecdotally with you, saved my clients bacon. The contribution is only for the costs of the action. Interim applications are excluded. I very recently was involved in a Rule 43 where the applicant claimed that her legal costs would be 1.something million rand. Of that, she included a bill of 350,000 rand for her Rule 43. And we were able to obviously kick out all of those costs on the simple principle that you are only entitled to a contribution of the main action and not interim applications such as a Rule 43. It's an old principle, service versus service, Micklem versus Micklem, and then Maas versus Maas, and I have shared the citations there with you. It's nothing new, but it is something that we often forget about in Rule 43 applications. The sum to be contributed is determined by the court's view of the amount necessary for the applicant to adequately put their case before the court. And then the final one, which is a killer point to take if your opponent wishes to claim a contribution for the whole trial, is very simply this: the applicant is ordinarily entitled to be awarded a contribution only up to and including the first day of trial. And the rationale behind this, ladies and gentlemen, in the case law is this: the matter can settle any day before trial. Any time before trial, this matter can settle. If the applicant has received a contribution to costs for 4 days of trial and the matter settles before or on the first day of trial, the applicant will obviously be unjustly enriched. Be aware, however, of Rule 43 6, where you can claim a further contribution to costs on the first day of trial if the matter runs over. It's not uncommon in divorce matters to see a quick Rule 43 application for further contributions to costs happening on the fly before the first day of trial or after the first day of trial, to provide for the poorer, open quote, close quote, spouse to present their case on the second day of trial, etc., etc. Now, there has been some controversy of late in our law, and I think this is a case that is still going to be far from fully laid to rest for some time, and that is the question of whether a spouse is entitled to claim for costs already incurred or only entitled to claim for costs going forward. It used to be a very, very well established principle in our law that you are only entitled to future costs. However, we have had the apple cart thrown over with extreme malice by the Western Cape High Court in two cases specifically, AF versus MF 2019 6 SA 422, which seems to suggest and flirts with the idea of allowing claims for past legal expenses. And then we have an unreported case of AG versus LG, which is referenced in Erasmus for those who would like to have a look at it, which really kind of goes the whole hog and says that you can claim past expenses, past legal costs under a claim for contribution to costs. Then let's go on to an interim care order in respect of any child. Now, folks, whilst we go into that, I would like to just backtrack a little bit and mention to you, Melissa, yes, the case citations are in the presentation, and I might distribute the case law as well. Brigitte, be nice to the Western Cape, we don't even have case lines yet. Brigitte, ek's jammer om van julle moeilikheid te hoor. And we don't have case lines anymore either. We have court online now, to the chagrin of all the practitioners in and around Johannesburg and Pretoria. Interim care of any child. Folks, we speak as practitioners working in family matters of primary residence and shared residence and nesting. Very important, folks. Keep this in the back of your head. We speak of them, but these are not recognized concepts, at least in terms of the Children's Act. The Children's Act does not have a definition for primary residence, shared residence, nesting, for example. These are all things that have come in on a very practical level in family practice. These residency regimes really find their roots in the contact and care provisions of the Children's Act, more in care than in contact. And I wanted to specifically, as tedious as it may seem, to take you through the definition of care in the Children's Act. And I force myself, and I force the attorneys in my practice to every now and then go back to what the definition of care is, because we so often get caught up in really just thinking about primary residence and contact, when really it's much broader than that. The concept of care is quite fluffy in certain regards. However, it is very, very important to keep this in the back of your head when dealing with matters regarding minor children. I'm going to scooch up right close to the screen to be able to read this to you with my spectacles. So please do forgive the extreme close-up of my face. Care in relation to a child includes, where appropriate, within available means, providing the child with a suitable place to live, living conditions that are conducive to the child's health, well-being and development, and the necessary financial support. You remember I mentioned to you earlier regarding the maintenance, which really finds itself rooted in care of a minor child, and there is the evidence to that effect. Safeguarding and promoting the well-being of the child, protecting the child from maltreatment, abuse, neglect, degradation, discrimination, exploitation, and any other physical, emotional, or moral harm or hazards, respecting, protecting, promoting, and securing the fulfillment of and guarding against any infringement of the child's rights set out in the Bill of Rights and the principles set out in Chapter 2 of the Children's Act. Guiding, directing, and securing the child's education and upbringing, including religious and cultural education and upbringing, in a manner appropriate to the child's age, maturity, and stage of development. guiding, advising, and assisting the child in decisions to be taken by the child in a manner appropriate to the child's age, maturity, and stage of development, guiding the behavior of the child in a humane manner, maintaining a sound relationship with the child, accommodating any special needs that the child may have, and generally ensuring that the best interests of the child is the paramount concern in all matters affecting the child. So I want to very, very gently address the family professionals that are in this meeting today. We are very tempted as family professionals to focus on the contentious issues, contact and primary residence. But it goes so much deeper than this, folks, and all of these aspects, if you have a look at just the plain wording of Rule 43 saying that interim care of any child can be dealt with in Rule 43, it takes it much further than just being die kind bly hier of die kind bly daar, or the child is with dad or mom or wherever. It takes it much further than that. And these are all issues that are capable of ventilation under Rule 43. I want to just pause to look at the wording, and I don't base this on any decided cases, but it's very interesting just on the wording of the Act that it talks about interim care of any child. It doesn't limit it to interim care of the children born of the marriage. And I find that extremely interesting. It really broadens it quite wide. Then let's go and look at the principles under care specifically. And I want to pause to talk about this principle of preserving the status quo and status quo doctrine. I am an absolute stickler when it comes to status quos, for lack of a better word. I don't like a status quo. Just because something is the norm does not mean it is good. As I so acutely realized this morning, load shedding is the status quo in South Africa. It is the status quo. It doesn't mean it's good. So, folks, when you do Rule 43s, understand that the principle of preserving the status quo is always subject to the consideration that the paramount interests of the children must prevail, and the status quo must not constitute an unreasonable state of affairs. As I mentioned to you earlier, the court is not going to overturn the whole apple cart at Rule 43. The court is not going to, unless there is seriously compelling evidence, make an order that is going to completely negate or upset the status quo. But even so, status quo is not absolute, ladies and gentlemen. Status quo is always second to the paramountcy of the best interests of the child. Right, then case law suggests also the court is entitled to refer an application for interim care to the family advocate in terms of Section 4 of the Mediation in Certain Divorce Matters Act. So that is it for interim care. Let's move on to contact. Once again, ladies and gentlemen, the Act talks about interim contact with any child, not necessarily just a child born of the marriage, interim contact with any child. And one can understand the rationale behind that, with mixed families being much more the norm than the exception. Children from previous relationships now forming a mixed family unit with children from another relationship on the other parent's side. Now let's talk about what is contact. Once again, folks, we are very, very focused on the terms contact and primary residence as family practitioners. However, what is contact? Let's go back to basics. What does the Children's Act say about contact? And the Children's Act says the following. Contact in relation to a child means maintaining a personal relationship with a child. Interesting how that's the first thing that the Act lists maintaining a personal relationship with a child, not seeing the child every so often. Maintaining a personal relationship with a child. And if the child lives with someone else, communication on a regular basis with the child in person, including visits and being visited. And 2, communication on a regular basis with the child in any other manner, including through the post. I love that they still have through the post there. And then secondly, by telephone or any other form of electronic communication. WhatsApp and Skype and Teams and Zoom and all of these wonderful things that we have these days. So contact, ladies and gentlemen, is not simply a midweek visit and a every second weekend visit. It is much more than that. Yes, it is under subsection B, Roman numeral 1, in-person visits, but it's more than that. And primarily, it's not just visits. Contact is not visitation. It's not access, as they used to call it. It's maintaining a personal relationship with the child. And that then goes into the B section. A is the what is contact. Contact is maintaining a personal relationship with a child, and I would go so far as to say B is the how. And you do that by communication on a regular basis, either in person or by alternative means. In theory, folks, Rule 43 is a very, very simple process. But I think, as you would have seen this morning, the best laid plans of mice and men often go wrong, or afgang agly. Unfortunately, what has happened due to the truncated or expedited manner in which Rule 43s are dealt with, there are applications which really require a very, very high level of sophistication in drafting. They are fraught with pitfalls, and as one judge in the Gauteng South Division commented at one point in a judgment, it is very much akin to playing litigation Russian roulette. You really don't know what's going to happen at court. They are extremely unpredictable applications and extremely technical applications. For those of you who have the privilege to have been in practice for some time, you'll remember the provisions of Rule 43, 7 and 8. In fact, the intent of the Rules Board was to keep Rule 43 so simple that advocates and attorneys were limited in their fees on Rule 43, something crazy. Could anyone recall what it was? I think it was 940 Rand for an advocate, and I think 700 and something for an attorney in Rule 43. Now, obviously, that shows the intent of the Rules Board at that stage, wanting it to be a very, very simple kind of thing. But simple never really is simple. And what we've seen is Rule 43, 7 and 8 have fallen into disuse, and it's led to where we are today, where the courts are trying to formulate better ways of dealing with Rule 43. So what I'm going to deal with now is simply the process as it stands in the rules. Now, the various divisions have different manners of dealing with Rule 43s, very notably in South and North Gauteng High Courts. We use the financial disclosure affidavit, which is an extremely powerful tool. For those practitioners who are practicing in other jurisdictions, and you would like me to go through the financial disclosure affidavit in the question and answer section, please do just indicate so in the comment box, then I'll do that. And I want to encourage you, if you are a practitioner outside of Gauteng, to start using the financial disclosure affidavit, because number one, it is a very, very powerful tool, both in litigation and in settlement discussion, because the parties have to really pin their colors to the mast. And secondly, because I think, given the way that the FDF is working in Gauteng, I think it's only a matter of time before it's going to make its way out to the other divisions in any event. So, without looking at the practice directions and the various quirks of individual divisions of the High Court, purely focusing on the rules, this is Rule 43 in a nutshell. The application is launched and it is accompanied by a notice in terms of Rule 43 2A. And that notice in terms of Rule 43 2A sets out exactly what the applicant wants to achieve in the Rule 43. It sets out the order that they want. That is accompanied by a sworn statement. The rule provides that it can be sworn to by the applicant or by their attorney. I've never seen an attorney depose to a Rule 43 statement on behalf of their client, but it is something that can conceivably happen in terms of the rules. This application is served on the respondent by sheriff, or it can be served by hand or any other agreed method on their attorney, and that is in terms of Rule 43.2. Once the respondent has received this Rule 43 application, the clock starts ticking, folks, and they basically, in essence, have 10 court days or 2 weeks, excluding public holidays, to deliver a sworn reply in the nature of a plea. And that sworn reply must then be delivered within 10 days to the applicant and or their attorneys, as the case may be. If the respondent does not file their Rule 43 reply within 10 days, they are ipso facto barred from doing so. It's much like a notice of bar in terms of delivering one's plea or any subsequent pleading. You are ipso facto barred. The period of 10 days may be extended by agreement between the parties. The rule makes provision for that. And in the absence of agreement, the court can uplift the bar and grant condonation for the late delivery of the Rule 43 reply. As a note to legal practitioners, attorneys and advocates, 10 days is not a lot of time on a Rule 43. If you are properly opposing this Rule 43 application, you are going to have to do analyses of bank statements. You're going to have to do a lot of fact-finding and preparation of documents to attach to your Rule 43 reply. Pro tip, start working on it the minute it lands on your desk. Do not wait until day 5, because you are going to be in quite a lot of hot water the last 2 or 3 days, and you might end up having to test your opponent's good graces in terms of a extension or an extension of the days to file your Rule 43 reply. What's very interesting, ladies and gentlemen, on Rule 43, there is no provision for a replying affidavit. So in most instances, the court sees only 2 sets of papers. Number 1 is the applicant's Rule 43 statement, and number 2 is the Rule 43 reply of the respondent. So the court is faced with 2 diametrically often opposite versions on the papers, and the court must then adjudicate on the matter accordingly. And it's unfortunate, but this has given rise in to a large extent of the split the difference principle. I give half of the difference between the two, which is not a legally sound principle at all, but we do see it unfortunately from time to time being applied in Rule 43 matters. What the rule provides, and it's not always applied accordingly in the different divisions, but what it provides is the minute the reply has been filed, the registrar must bring the matter for hearing on 10 days' notice to the parties before a judge. What happens in practice is the applicant would go and apply for a hearing date and would deliver a notice of set down. In terms of, and I've put here NB, see the practice manuals of the different divisions. We know, for example, in the Gauteng divisions, parties are expected to do practice notes and heads and index and paginate before the matter can be enrolled for hearing. Then the court may hear such evidence as it considers necessary. And I've quoted from sub-rule 43.5. And what often happens is parties seek leave to supplement their papers in terms of rule 43.5. So just because the standard papers are the Rule 43 sworn statement, the Rule 43 reply, doesn't mean that's the end of it necessarily. The parties can apply, either party can apply to file further affidavits if there is relevant and germane information that needs to be placed before the court. Then once the hearing at court has taken place, an order is generally granted. Thank you, Siri. An order is generally granted, which is an interim order to tide the parties over until trial. What happens, however, is during the course of the trial preparations, very often there is a change of circumstances. And in that instance, either of the parties can approach the court in terms of Rule 43.6 to seek a variation of the Rule 43 order. Rule 43.6 also is utilized when the contribution that has been made to costs was not sufficient to cover the full litigation costs of the applicant. Anecdotally, what a lot of attorneys do is they go to court and say, look, I want a provisional contribution to costs or an initial contribution to costs and give me 20 grand or whatever the case may be. That's not necessarily sound. If one looks at the case law, in my opinion, the idea of the contribution to costs, if one looks at the case law such as senior versus senior, etc., is that one does a bit of a thumbsuck exercise. You prepare your draft bill all the way up to first day of trial, and 43.6 really comes into play on the first day of trial. But that is simply my opinion. I do not base it on anything more than just my own reading of some of the case law. Then let's go into key principles in terms of Rule 43. The first one, and why Rule 43s are such a dangerous thing, there is no appeal. This was tested some time back. I believe the appellant in that case tried to take it all the way to the top and was very, very promptly shot down. There is no appeal to an interim order. If an order is interim in nature, you simply cannot take it on appeal, and you must live with it on an interim basis. Obviously, as all of you have the capacity to imagine, and some of you would have seen yourselves, this is very often capitalized on by unscrupulous litigants. They try to run to Rule 43 court, get a cushy order, and then try to delay the proceedings as far as possible. I inherited a matter which I was very, very fortunate to be able to have helped the client to sort it out within about a year of us getting the matter. But in that case, a Rule 43 order was granted in 2012. And the client had been living with that order all the way up until 2021 when she approached us and we were able to resolve the divorce. But as you can imagine, these Rule 43 orders have very far-reaching consequences, especially if there are delays in the finalization of the divorce proceedings. Just for those who are interested, Section 16.3 of the Superior Courts Act is where the principle that there is no appeal from a Rule 43 judgment can be found. Then, Very important, Rule 43 deals only with pending matrimonial disputes and has no application to any matrimonial dispute which has come to an end by final divorce. This is a critical principle. The minute the divorce is finalized and there is no order for maintenance, in terms of Section 7.2, the door has closed on spousal maintenance claims. Very important in terms of Section 7.2, and also obviously in terms of getting further relief, for example, in cases where the decree of divorce is granted and litigation continues in terms of calculating the accrual, the applicant may have a very hard time. Rule 43 applications apply both to pending matrimonial actions and to actions about to be instituted. So one of the questions that one is asked very frequently is, does there have to be litigation already pending before you can do a Rule 43? Not necessarily. It can be in anticipation of proceeding with the main divorce action. Then there's a very important principle. It's an old principle, but I did feel it worth mentioning today. In tort versus tort, a claim supported by reasonable and moderate details carries more weight than one with extravagant or extortionate demands. Similarly, more weight will be attached to the affidavit of a respondent who evinces a willingness to comply with their legal obligations rather than to evade them. That's tort versus tort, and that is obviously the importance of, if you are acting for a respondent who is a person of means against an applicant who has no means, it is incredibly important to discuss with your client the possibility of making a tender. Stalingrad defenses are a recipe for disaster in Rule 43. And finally, this also goes into one of the questions which we will be dealing with in the second portion, which will start imminently. Papers should be concise, factual, and accurate. Most of you will remember Dupree versus Dupree, where the court reiterated that the applicant has a duty uberime fidei, i.e. of the highest echelons of good faith, in deposing to their Rule 43 affidavit, and the court is justified in refusing relief on the basis alone that the applicant has failed to comply with their duty uberime fidei. So be aware that papers should be concise, factual, and accurate.
The information contained in this video is distributed free of charge for educational purposes. Whilst we have taken all reasonable steps to ensure that the information contained herein is correct and up to date, insofar as the law in South Africa is concerned, the law remains a nuanced and complex field of study, replete with many exceptions and conditions. Please, therefore, do not utilize this information as legal advice, which it is not. When in doubt, consult with a legal professional. For more information, please feel free to contact our offices.